Thank God he was single.
Okay.
Are you going to start?
Yeah. Good morning. Welcome to a special session of the Public Safety Committee. It's my honor to chair this committee. This will be the last committee of the year, I believe. And we're very, very excited to hear a presentation from Senator Hancock in regard to an issue that we all know about, have read about, probably have spoken about, and that is the death penalty. I know there'll be strong opinions on either side and maybe even some gray. And I all know that we're eloquent and a little overeducated, a little oververbal. So if you would keep in mind time restraints, it's a busy time of year for all of us. I envision the hearing maybe being an hour to two at the most. And with that, Madam Clerk, could you take a roll call, please?
Amiano?
Here.
Knight?
Here.
Cedillo? Hagman?
Here.
Hill?
Here.
Mitchell? Here. Skinner?
Here.
All right, and Senator Hancock, if you'd like to approach the bench.
Thank you very much, Mr. Chair and members of the committee. I'm here today to present SB 490 and would like to begin by taking as author's amendments the correction to the drafting error made by Ledge Council on page 14 to replace appeal to approve. We discussed this with committee staff, and I'm pleased to take that amendment. On the bill, SB 490 will place a measure on the ballot replacing California's death penalty with permanent imprisonment, also known as life imprisonment without the possibility of parole. The measure requires that people convicted of the most terrible crimes be kept in a maximum security prison for the rest of their lives. We all want swift and certain punishment. We all want to punish serious crimes with serious consequences. As chair of the Senate Public Safety Committee and a member of the Senate Budget Committee, my decision to introduce this measure came from two factors. Experiencing, as we all did, the heartbreaking cuts that we made to public safety, to our children's education, and to other of the quality of life issues that have kept California a wonderful place to live. And the study released last week by law professor Paula Mitchell and former prosecutor and senior judge Arthur Alarcon, based on previously unavailable records from the Department of Corrections and Rehabilitation that outlined the shockingly high cost of maintaining the death penalty. We all want safe streets and safe communities. As a senator that represents cities of Oakland and Richmond that have real issues with violence in the community, as a mother and grandmother with grandchildren growing up in Oakland, I know that we need safe streets, safe communities, and I know the devastating consequences that violence has had on people in our communities, and I believe we can do better. As I have done more research on the death penalty, I have found there are reasons beside financial for replacing the death penalty with imprisonment without possibility of parole. The death penalty is not swift and certain punishment that experts tell us is most effective in deterring crime. Since 1978, when voters approved the death penalty, only 13 people in California have been executed, 13 in 33 years. 18 have committed suicide, 55 have died of natural causes, but there are still 714 people on death row at a cost of $184 million a year, according to Judge Alarcon and Professor Mitchell. They say that people who plan crimes like murder don't ask themselves, will I be executed or will I die in prison of old age? They ask, will I get caught? And too often in California, the answer is no. 46% of the murders in our state every year go unsolved and unpunished. To deter murder and violence and apprehend those who kill and hurt others, we need to increase police on our streets, education involvement for our young people, and programs that are being cut, like recreation programs and libraries that keep kids safe and off the streets. Another problem is that mistakes are made. Human error is in every system, and you can't undo death. Nationally, 139 men and women have been released from death row when DNA evidence or subsequent confessions or other things proved that they were innocent. In March, Illinois became the 16th state to end the death penalty when the governor signed legislation replacing it with life without the possibility of parole. This answer came after DNA and other evidence indicated that 12 persons had been executed for crimes it turned out they did not commit. In 2008, the Commission on the Fair Administration of Justice, a bipartisan commission in California, declared that there's a serious possibility that California could execute an innocent person unless we improve our present system. Already 3 people in California who were wrongfully convicted and sentenced to death were later found to be innocent. But at a time when we do not have the money to meet the basic needs of our people, we can't afford a punishment that Judge Alarcon calls a punishment in theory only. $80 million a year could put a lot of police officers on the street, send a lot of our kids to college. Capital punishment is an expensive failure and an example of the dysfunction of our prison system. California's death row is the largest and most expensive in the United States, and it is not helping protect our people. It is helping to bankrupt us. The death penalty is a hollow promise to victims, not swift or certain. We need to spend that additional, according to Judge Alarcon, if we were to speed up the process, it would cost an additional $85 million a year. The Commission on the Fair Administration of Justice said $95 million a year. So some amount of money, and bear in mind we just cut the University of California $200 million. So it's a large sum of money. In conclusion, we have not been being tough on crime. We've been being tough on the taxpayer, tough on the people of California. Every dollar we spent on failed policies like the death penalty means police officers we don't put on the street, teachers we don't put in the classroom. And those are the things that would make for truly safer communities. The people of California deserve safe communities, and they deserve justice when terrible crimes are committed. Judge Alarcon says that his report was designed to explain to the voters the cost in tax dollars of implementing a death penalty. Californians deserve to know the truth. They deserve education for their children. They deserve police officers in their community. They deserve to have this on the ballot, because this measure would place on the ballot for voter consideration replacing the death penalty with life imprisonment without the possibility of parole. To have this issue put before them again 33 years later so they can decide with full information whether or not to continue what I believe is a failed policy. I have 3 witnesses with me today Judy Kerr, sister of a murder victim and spokesperson for California Crime Victims for Alternatives for the Death Penalty. Jeannie Woodford, former warden of San Quentin State Prison, where she oversaw 4 executions, and was later secretary of the California Department of Corrections and Rehabilitation. She's currently the executive director of Death Penalty Focus, a national nonprofit organization. And finally, Don Heller, the author of California's death penalty law, Proposition 7, in 1978, who now believes that the law should be replaced. So I'd like to refer
Thank
to
you
my witnesses.
very, very much, Senator. And usually we have a 2-minute, 2-witness rule, but we are going to massage that today and allow for 3 minutes and 3 speakers in support, maybe do some Me Too's. And if either side, opposition or support, has some things that they'd like to present, we will be flexible.
Thank you very much. Oh, okay. You're going to go first. Go.
Good morning. I'm Don Heller. I'm an attorney in Sacramento. I'm a former state prosecutor from New York, an assistant U.S. attorney in Sacramento for 4.5 years. I spent 8.5 years as a prosecutor. I wrote the Briggs Initiative in 1977, shortly after I left the United States Attorney's Office. I was given the charge of writing a comprehensive death penalty statutory scheme which would cover many serious felony homicides, the most serious of the homicides that are committed on a regular basis throughout this state and probably throughout this country. I did my job very carefully in accordance with U.S. Supreme Court jurisprudence to make sure that the initiative was going to be fair and impartial in its language, with the hope that it would be implemented with fairness and an appropriate sensitivity to all concerned, from the defendant to the victims. I was a committee of one. There was no discussions as occur in the legislature. There was no vetting of any of the clauses and provisions in the initiative. I decided what was going to be in it as long as it met my charge of covering multiple additional special circumstances. Most importantly, and one of the reasons I fervently believe that capital punishment should be abolished, and now there's statistical evidence that never existed at the time I wrote it, and in fact, it was never a consideration by me or anyone else. It was never discussed at all with Senator Briggs or anyone concerned. There was some comment on what it might cost. Those estimates were grossly below what it ended up costing. And that is probably critical to the underlying problem with our death penalty statutory scheme. When I wrote it, the death penalty defendants had 2 court-appointed lawyers, and 99.8%, I believe, of the cases, homicide cases, death penalty cases prosecuted in this state, are court-appointed cases. So we have court-appointed lawyers. You get at least 2, but usually there's more because of the discovery of DNA and the significance in murder cases. Defense has to pay for, the state has to pay for DNA experts for the defense. They pay for investigators beyond the standard private investigator to investigate into background. There's an investigator just looking for evidence and mitigation because the statutory scheme requires that a defense present mitigating evidence. We have jury consultants now. We have a whole plethora of different experts, depending on how a particular crime was committed, from as I mentioned, DNA, forensic medical examiners, fingerprint experts, a ton of experts.
Sarah, I'm going to ask you to wrap up, but
Okay.
I know that there will be questions.
Sure. And that doesn't take into account the appellate lawyers and the habeas lawyers. It's costing the state a huge amount of money. We've executed 13 people since 1978, 1 under the Deukmejian death penalty, 12 under the initiative, at a cost of about $330 million per execution.
All right. Thank you, Sarah. It's very happy to have your testimony, and maybe I'll talk to you about the Briggs Initiative another time. All right. Next speaker, please.
Good morning. I'm Jeannie Woodford. I have over 30 years of experience in law enforcement. I'm currently the Executive Director at Death Penalty Focus. Chair Amiano and committee members, I want to thank you for allowing me to testify in support of Senate Bill 490. This bill will allow the voters to decide if the death penalty should be replaced with a punishment that provides for public safety while reducing cost, increasing the efficiency of our courts, and most importantly, ending the years of uncertainty experienced by victims and victim family members. Life without possibility of parole is a solution for addressing what opponents and proponents of the death penalty recognize is a broken, costly, failed system that does not provide meaningful public safety or justice to our families, despite the billions of dollars spent. I spent nearly 27 years at San Quentin working from correctional officer to warden. I carried out 4 executions. My experience allows me to talk about this issue as few others can. Most inmates spend decades on death row only to die of natural causes or to have their sentence overturned and changed to life without the possibility of parole. Of those sentenced to death in California, only 1% have been executed. It is wasteful and counterproductive to public safety to spend our precious, precious resources pretending we have a death penalty when we know this sentence will not be carried out 99% of the time. It is also terribly unfair to victims' families. Life without the possibility of parole is a real sentence. It is a harsh sentence, and it is an appropriate sentence. These individuals will remain in prison forever unless they prove their innocence. They are safely housed in our maximum security prisons. They are expected to and do work within our prison system. This does not mean that their sentence is easy. It is not. It does mean that they are held accountable and must follow the strict program expectations of the Department of Corrections. After each execution, someone on my staff would ask, "Is the world safer because we did our jobs tonight?" We all knew the answer was no. What makes us safer is solving crime and sentences that are certain. 16 other states have come to recognize the futility of the death penalty. I encourage you to vote yes on this bill to provide the voters of the state of California the opportunity to make this state the 17th state to decide our resources are better spent improving public safety and the lives of those impacted by crime. Thank you.
Thank you very much. Next witness, please.
Good morning. My name is Judy Kerr.
Want to speak into the mic? Thank you very much.
Good morning. My name is Judy Kerr, and I want to thank you also for the opportunity to speak with you today. When my brother, Robert James Kerr, was murdered in 2003, my life was turned inside out. I read in horror the coroner's report that detailed his brutally beaten body. And I expected then that justice would be swift. I trusted that my family would soon have some sense of the circumstances leading to his death. And I worried that Bob's murder trial would drag us through gruesome details of his murder. I also worried that his trial would become a capital case. Although I desperately want Bob's killer to be apprehended and to be punished, I do not want someone else's brother to be killed. And I did not want at that time to wait 25 years for the case to finally close. This coming Monday will be the 8th anniversary of my brother's murder. As of today, we don't know who killed him. And like so many other murder victim family members in California, his case is unsolved and his killer walks free. My position on the death penalty hasn't changed since Bob's death, but my reason for opposing the death penalty has become more focused and more personal. Today in California, we're laying off police officers, we're closing crime labs, we're eliminating victim services, and we're ending cold case investigations. And today in California, we have a crisis of unsolved murders that are over 45%. Today, there are thousands of murder victim families like me who watch while we throw millions of dollars every year into a farce of a justice system that does nothing to address the real needs of families. And today, in this Public Safety Committee meeting, you have the opportunity to lead the voters of California toward what it can be a truly tough on crime policy, a policy that does not shortchange public safety or victim services. Today, we have a chance to acknowledge that while revenge will feel right sometimes, it will never make us safer, and it does not help victims' families. California Crime Victims for Alternatives to the Death Penalty is a coalition of over 650 murder victim family members who support alternatives to the death penalty. After the horrifying loss of loved one to homicide, they are left with a clear awareness that the death penalty fails to address the needs of victims on every count. The coalition does not endorse or specify any reason for opposing the death penalty, but it supports all families in telling their stories and educating the public about alternatives to the death penalty. I have some materials for the committee that I'd be happy to share with you.
Thank you very much. The sergeant will deliver those. All right, thank you. I am now going to ask for any other witnesses in support. If you would approach the microphone. Go ahead, sir. I'm going to give you all about a minute, a little different than we usually do, and the same will apply to the opposition.
Thank you, Mr. Chair and members. Larry Doyle on behalf of the Conference of California Bar Associations. The conference is a group of attorneys representing 25 bar associations statewide, including major local, metropolitan, and especially bar associations, and its membership includes both prosecutors and defense counsel. The conference has voted consistently over the years to support resolutions abolishing the death penalty. Some of them believe the death penalty is right, some believe it is wrong. All believe that the death penalty as it exists in California today is expensive, wasteful, and the money could be better spent elsewhere.
Okay, thank you. Next speaker, please.
Chairman Amiano, members of the committee, I'm Diane Bellis, the Alameda County Public Defender, a former commissioner on the Commission on the Fair Administration of Justice, and I'm here today representing the California Public Defenders Association. Almost all of us here have at one time invested in a device that we believed would help us solve a problem or make our lives better. And then before we know it, we don't use it anymore because it turns out to be too cumbersome, outdated, and an obsolete machine. We become aware of better, less unwieldy devices that would accomplish the same thing for us and at lesser cost. For some of us, we see it as an embarrassing reminder of how much we paid for what we believed at the time to be a good investment. In our system of criminal justice, in this House, the death penalty is that obsolete machine. The last time I tried a death penalty case, it began with 4 defendants and 8 attorneys.
Okay.
It took 6 years from start to finish, and the result was life without parole. I urge your support of this bill. Thank you.
Thank you very much. Next speaker, please.
Linda Warner with the California Catholic Conference of Bishops, and we are in strong support, and we hope that you give the voters the opportunity to decide. Thank you.
Thank you.
Mark Carlson, Lutheran Office of Public Policy. We also support allowing our church members to vote. The lead story this morning, or one of the lead stories on KCBS radio, was the budget cuts to the Bureau of Narcotics Enforcement. I think that speaks for itself as far as the budget kind of trade-offs we're experiencing. So we would like our chance to vote on budget priorities. Thank you.
You?
My name is Amanda Wilcox. I am the mother of a murdered victim. Laura was 19 when she was killed in a rampage shooting, and I support this bill. I believe that the resources spent in implementing the death penalty should be redirected towards true crime prevention, as if you have already heard, and for victim services. Thank you.
Thank you.
For the record, I am Nick Wilcox, also representing California Crime Victims for Alternatives to the Death Penalty. As the father of a murder victim, I'm aware that the death penalty is often justified in the names of those parents, and we are simply here today to say that the death penalty does not satisfy us, and to the world we proclaim not in our name. Thank you.
Thank you, sir. Next speaker.
Hello, my name is Lorraine Taylor, and I am founder of 1,000 Mothers to Prevent Violence. In the year 2000, I lost both of my twin sons to gun violence in the city of Oakland. The cases remain unsolved. I believe that the death penalty is another act of violence, whereas life without the possibility of parole will ensure public safety. And I hope that you will vote yes on SB 490. Thank you.
Next speaker, please.
Good morning. I'm Michael Millman. I'm a lawyer who spent the last 33 years of my life representing capital appellants and assisting other lawyers in doing so. From that experience, I have some data about the time and costs involved in these cases, and if making that data available to your committee would be of use, I would be happy to do so. Thank you.
Thank you, sir.
Good morning. My name is Stephen Munkelt. I'm appearing for California Attorneys for Criminal Justice, and I'm currently the Legislative Committee co-chair for CACJ. Our organization, with 1,500 members who have represented defendants throughout the criminal justice system, can say that there is no public safety benefit for the death penalty as it's presently constituted. There's no possibility of making it work effectively and accurately without spending a whole lot more money, and that the interests of the state of California are that this committee pass the bill forward and the voters get an opportunity to reconsider this policy.
Thank you.
Hi, my name is Susan Ten Kwan. I am here representing California Attorneys for Criminal Justice, and I am also a member of the State Public Defender's Office. I've represented capital defendants since 1987. I've represented over 10 capital defendants as lead counsel or second chair of counsel, and also have assisted in over 35 other cases at the California Appellate Project. I am in favor of this bill. I believe that the capital punishment system in California is dysfunctional. It's a waste of money. And I do believe that life without possibility of parole will ensure public safety and is, a reduction in the cost to the state of California. Thank you.
Thank you very much. Next speaker.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. We think the public is made safer when murderers are apprehended and removed from the streets. We see no benefit to public safety when they are condemned to death. Given the huge cost and the dysfunctionality of the system, we think voters deserve an opportunity to reevaluate their support for capital punishment in California in support of SB 490.
Thank you. Next speaker.
Hi, my name is William Butkus. I'm here representing Amnesty International, and we are in support of SB 490. Thank you.
Good morning. My name is Elizabeth Zitrin. I'm an attorney from San Francisco. I have the honor to be represented by Chairman Amiano. I am on the steering committee and the executive board of the World Coalition Against the Death Penalty, an international association of 121 organizations in more than 35 nations on all 5 continents. As you know, the United States is in the minority of nations of the world that still have the death penalty. Since the Briggs Initiative reinstated the death penalty in California, the vast majority of nations of the world have abandoned this practice. California now is in company with the worst human rights violators in the world: China, Iran, Iraq, Saudi Arabia, and Pakistan. California voters favor an alternative to the death penalty. The world is watching, and we urge California to join most of the world and support this bill, allow Californians to vote on it. Thank you.
Thank you very much. Next speaker, please.
My name is Stephen Reese. I'm an attorney. I'm with the California Attorneys for Criminal Justice. I've handled 5 capital cases in my 30-some-year career. It doesn't work. It just doesn't work. As the other speaker said, it is a tremendous waste. You think it's going to achieve the result. It does not. And I would just ask you to remember the words of Justice Frankfurter. He once said, "Wisdom too often never comes. One ought not to reject it because it comes late." Thank you, and please vote for this bill.
Thank you.
Natasha Minsker, Death Penalty Policy Director for the ACLU of California. On behalf of our 100,000 members and supporters here in California, I urge you to vote yes.
Thank you very much. Are there any other witnesses in support? Please approach. No more. All right, that's it for support. Okay. Witnesses in opposition, if you want to approach the table, we'll have the same format. All right, thank you very much. By my calculations, we kind of made the 3-minute, 3-witness time frame. So I want to extend the same to you, and if there's a need to make another point or something, that's fine too. So whoever would like to start.
Good morning, Mr. Chair and members. Corey Salzillo on behalf of the California District Attorneys Association. We are very strongly opposed to SB 490 as it's before you today. We share the public's support of the death penalty, which as currently constituted is a legally appropriate and carefully measured response to the most heinous crimes the society faces. The death penalty deters future criminality, if by no other means than by permanently incapacitating potential repeat offenders. The law acknowledges the fact that certain offenses are so serious that a penalty for violations thereof, as strong and final as death, must be available. The retroactive nature of this bill, inasmuch as it converts existing death sentences to LWOP, is extremely unfair to communities that expect justice and to victims' families who have been promised ultimate closure. And we agree with the author's frustration over the cost of administering the death penalty, but that's unfortunately where the agreement ends. We have a great concern with the notion that we should get rid of the death penalty just because it's expensive to administer. And those have been the lead arguments by most of the proponents and the author today. It's expensive, not that we've executed someone wrongfully or that it's an inappropriate punishment. It's that it's too expensive. We cannot put a price on justice. This association has sponsored and supported numerous bills over the last several years that address both cost and efficiency issues, including expediting the certification and correction of the record and faster appointment of appellate counsel. And these bills have been roundly rejected in both houses of this legislature. We simply cannot agree with a course of action that eliminates the death penalty when common sense remedies to many of the operational impediments to the death penalty have been identified but promptly rebuked. The conversion of death sentences to LWOP certainly raises constitutional separation of powers issues, inasmuch as the legislature would be effectively changing sentences that were appropriately imposed by the judiciary. And even if you believe that a gubernatorial signature on the bill qualifies as a commutation, Article 5, Section 8 of the Constitution of California provides that though the governor may grant a commutation on his own accord, he can only do so if the person is not twice convicted of a felony. So it would not apply to all people who are on death row.
It should say he or she.
He or she, excuse me. I was just referring to the existing governor,
okay.
Current one. Further, we think the moratorium proposed in the bill is illegal at best, and at best sets a dangerous precedent. Section 7A seems to halt executions until the voters act on the question posed by the bill, but the bill cannot take effect until the voters enact it. It's unclear how this bill could have an effect before it actually takes effect. And whether or not there is a de facto moratorium on the death penalty is irrelevant in the analysis of this issue. And for all these reasons, we'd respectfully ask for your no vote on this bill.
Thank you very much, sir. Next speaker, please.
Thank you, Mr. Amiano. My name is Curtis Hill. I'm representing the California State Sheriff's Association. On behalf of the 58 sheriffs in California, I'd like to thank you for the opportunity to speak before this body today. Also like to thank Senator Hancock. She invited state sheriffs to her office to discuss this matter last week. The 58 sheriffs of California at this point have not taken a formal position on this bill. However, I think it's likely going to be an oppose. I'd like to point out something interesting, and I agree with the District Attorneys Association and their assessment of this bill so far and their interpretation of it. There's a bill in this body currently moving through this building, SB 9, which will allow juveniles who have been convicted of, in Division of Juvenile Justice currently for life without parole, an opportunity for them to appeal their case. We feel that that is indicative of where this will go if the voters approve the matter. That's a possibility. We're confident that the voters will speak when this bill goes before them, if it does go before them in a vote, as over 60% of Californians currently are in support of the death penalty. We continue to work every day in this state and law enforcement officials. California spends billions and billions and billions of dollars every year on law enforcement, public safety in this state to keep our 38 million Californians safe. We feel that the issue of the death penalty costing too much is a very interesting notion. However, we will continue to work with the author and with the legislators in this building moving forward in this matter. Thank you.
Thank you, sir. I appreciate it very much.
Thank you. Dawn Kepke with McHugh and Associates on behalf of Crime Victims United of California in strong opposition to this bill. With all due respect to the author, whom we hold with very high regard, as well as the proponents and particularly those victims who support this bill and the abolishment, Crime Victims United of California and the victims we represent believe that this bill and this effort is an insult to those victims who have offenders serving on death row and believe that they were provided justice for the atrocious crimes committed against them and their families. Although these victims have waited decades for justice because of the long delays associated with the system, and we do agree that the system is highly dysfunctional, the concern that the victims I represent have is that this ultimately says, because of the arguments related to cost that seem to be the primary reason for pushing this bill forward, is that victims and their loved ones who have suffered at the hands of these atrocious offenders, the cost of their life is not as sufficient and important as the cost to the state for the justice that they were provided. This type of issue, I mean, how can we go to, Mark Klass, whose daughter Polly Klass was killed and whose offender sits on death row today? Sharon Rocha, the Rocha family, whose son-in-law, Scott Peterson, killed his wife and her unborn child. All of the Manson victims and the hundreds and hundreds of other victims that died at the hands of these atrocious offenders. How do we go to them and say that although you thought you received justice, the court provided a sentence to you that was just for the crime that was committed against you and your family? Sorry, we're going to take that away now. We're going to make it now a life without parole sentence, one that very likely in the future, given the direction of many efforts that we undertake here in the Capitol, will likely even try to be eroded as well, because we're constantly looking to lower sentences, provide credits for some of what we consider the worst of the worst offenders out there. With regard to the costs associated with this, CVUC agrees that the system is very costly, no question about it. This is, in our opinion, as a result of the significant delays related to appeals processes and others, and these cost drivers need to be addressed. There are, as the DAs have said, there have been a number of proposals to attempt to get at some of those cost driver issues. Unfortunately, we just have not had the ability to move those and actually make a difference as far as the costs go. We understand, and CVUC also is very concerned about the cuts made in the budget, whether that be to public safety services, health and human services, and others. We're very concerned about that. For years now, Crime Victims United has provided a list of numerous cost-saving proposals, both for corrections and other policy areas that would help address some of the significant cost factors and try to help the state save money. And unfortunately, those have fallen on deaf ears, and instead we turn to something like the death penalty, which again, Crime Victims United believes is unfair to victims. With regard to victims that may not wish for their offender to be provided a death sentence, we would argue that in the sentencing proceedings and other parts of the trial process, under Marcy's law, victims now have even a greater role in the ability to have their voices heard. In that regard, I'll wrap up. Absolutely.
Yeah, and then there'll be questions.
Please,
thank
absolutely.
you so much.
With regard to that process and the additional rights provided to victims who may not want the death penalty to be an option for their particular offender because of their philosophical beliefs, they have the ability to put that in their victim statement to provide to the court, and additionally have the ability to confer with the DAs and others. So we think that for all of these reasons, we're adamantly opposed. Thank you.
All right, thank you very much. Are there any witnesses in opposition? If you would approach the mic.
Mr. Chairman and members, I'm Jim Votes, today representing the Long Beach Police Officers Association, the Santa Ana Police Officers Association, the Association of Orange County Deputy Sheriffs, the Los Angeles County Professional Peace Officers Association, the Sacramento County Deputy Sheriff's Association, and the California Fraternal Order of Police. We are all opposed to SB 490.
Thank you, sir. Next speaker.
Good morning, Mr. Chair and committee. My name is Ron Cottingham. I am the president of the Peace Officers Research Association of California. I'm here today representing my 900 affiliate associations comprising 62,000 individual members. I am also a former commissioner on the California Commission for the Administration of Justice, and I am a victim, or I have my 72-year-old father-in-law was brutally murdered during the commission of a burglary in National City, California. So I speak to you for him and for my wife. We are adamantly opposed to this bill and ask for your no vote. But what I will say, that if you pass this bill out and make the killing of a peace officer, of a first responder, life without possibility of parole, and some of the other heinous crimes, you have put a target on the backs of my members and every peace officer in the state of California, when the gangbangers out there know that all they will get for killing a peace officer is 3 hots and a cot for the rest of their life. Additionally, please, sir, it was mentioned before, but I do think this body out here and the citizens of California need to know that life without possibility of parole is not the finite sentence they think it will be, because in this body today, you are considering amending life without possibility of parole.
Thank you, sir, very much. We would like everyone to honor the 60-second rule. Thank you.
Yes, Tim Yarian representing the Southern California Alliance of Law Enforcement, 37 law enforcement groups, Association for Los Angeles Deputy Sheriffs, Los Angeles Police Protective League, Riverside Sheriffs Association. We opposed the bill, and I'd just like to expand on Mr. Cunningham's statement. For a peace officer, the death penalty is a lifesaver. It provides an invisible shield around that officer. If somebody is going to kill a cop, they know they're going to face a death sentence. It's going to protect that police officer. It's going to protect that citizen. We can't know the statistics because we can't sit in the mind of everybody that doesn't pull a trigger or pull a knife, but we know that it's a deterrent. It doesn't work in every case, but it's something that we should look at as a benefit to society, not as taking a life, but as saving lives. Thank you, sir.
Thank you, sir. Next speaker.
Good morning, Chair and members. Kate Bell on behalf of the State Coalition of Probation Organizations in opposition.
Thank you.
Thank you, Mr. Chairman and members. Aaron Reed, representing PORAC. I want to identify with the comments of my boss, Ron Cottingham, the president, and to say that those same comments apply to our other client, the California Association of Highway Patrolmen. No agency has probably lost more officers in the line of duty than the CHP. You heard from some of the widows at your last hearing on SB 9, so I won't repeat what was said, but it's certainly, when you're in a uniform, you're marked. They go to work every day wearing a bulletproof vest. They know that day may be their last. And the thought that when a criminal shoots and kills a police officer that they face the death penalty is, we believe, a strong deterrent and must be retained. Thank you.
Thank you very much. Any other witnesses in opposition?
Mr. Chair, may I just briefly, I neglected to also inform you that the Los Angeles County District Attorney wished to be here specifically, but they were unable to do, and they asked me to also indicate their specific opposition to the bill.
All right. Thank you, sir. All right. Members, questions? Mr. Hagman.
Thank you, Mr. Chair. And I know we're trying to speed up this process, but there's a lot of numbers, there's a lot of points being brought up, and I'd like us to, with the Senator's indulgence, go through a couple of them.
Sure.
First of all, Senator, do you have any idea how many, let me first state off and agree with you, the system is broken. It does take too long to go through this process. It does cost the taxpayers too much money. We're higher than any other state who does this, and I believe there's 34 other states that still have the death penalty at this point. A number of legislators, including myself, has brought up reform measures to this body, either the Senate or the Assembly side, and my rough calculations are a couple dozen. I'm just wondering, do you know any specifically numbers of that, or maybe some of your witnesses of why some of those reforms to speed up the process may or may not have taken place on those?
You know, I don't know why they haven't. I can only speculate. But one thing I do know is that to fix the current system in terms of speeding it up in constitutional ways has been estimated to cost $95 million a year by the Commission on the Fair Administration of Justice and $85 million a year by Judge Alarcon's report, which is based on statistics and data from the California Department of Corrections and Rehabilitation. I think that the real, as a legislature, we weigh all the time, what aren't we going to do because of the huge needs in every area of life in California. So that, but I can't answer definitively for other legislators.
Okay, to go back to the numbers a little bit, I'm actually looking at the breakdown of the judge's study, and the majority of the money goes to incarceration costs. I have it down to $71.7 million on this. And understand we do things like we have each one of the defendants in their own cell versus what we do in regular population where we put multiple people per cell. We have them on a particular location where we could transfer to other level 4 facilities. But that number seems quite high per inmate, obviously, because they have their own prison. And that's strictly the incarceration cost, not the litigation cost. So I don't know what would change. What would you, under your proposal, if it was life possibly parole, would they be taken out of this facility, and why can they not do that now to bring down those incarceration costs?
Okay, I'd like Jeannie Woodford, who actually presided over death row in San Quentin Prison, to.
Thank you. Well, currently the Penal Code says that all males sentenced to death will be housed at San Quentin State Prison, and at San Quentin State Prison. In addition to there are legal concerns about having death row inmates double celled, and most states do not double cell them. But if you wanted to double cell them at San Quentin, you're prevented from doing that because of the size of the cells and a old court case that stated you could not double cell inmates in segregation at San Quentin.
Okay, so but something these are different parts of the process. I went through each part in our study and. Who's considered qualified attorney is much more restrictive here than the federal, for the appellate attorneys. We go through each step of the process that takes 6 or 8 years for that process to go through. If we adopted this to federal standards on appellate, unnecessary restrictions on the appellate judges, that would free up a lot more of these attorneys to be able to take these cases so it doesn't have a 6-year wait before they have the first appellate judge. The large briefs that are excessively under our Ninth Circuit, And looking at our justice system in the Ninth Circuit, we could compare the most we could with, I guess, Arizona, because they have the death penalty in the Ninth Circuit as well. Yet they seem to be cost a lot less and take far less time than we do, almost 10 years, versus ours are going 20-plus years now. So I'm just wondering, why can we not put some of these reforms, if it is a cost issue, and if we could bring this time period down from 20-plus years process down to what even in our own Ninth Circuit neighbor does in Arizona, bring it down to roughly 10 years, you would think that would drop down the cost quite a bit, at least in half, just simple math. And then you also, the alternative to that is, let's say we do 30 years at $50,000 a year per inmate. That's roughly, at the 720 we have right now, close to $1 billion right there alone in incarceration costs at our current rate. So I think we have to look at this in context of not throwing out the system or getting rid of it, but what can we do to reform the system as well, and to have all these folks who are against or for this measure that are saying it for financial reasons. I think that'd be a great partnership to figure out what can we do, what can we learn from other states that do this much more efficiency and still keeping justice there. We want to make sure that the wrong person doesn't get through. But like was brought up, new technologies like DNA and all the new forensics evidence, that should separate those ones that had doubt. I know I personally have someone from my area that I represent the victims. That's Kevin Cooper. That's been through, I think, 6 or 7 appeals, been on death row for 23-plus years. He's lost every one of them. It's been matched, the first case for DNA that matched and proved his guilt, but yet he's still waiting for yet another court-of-peer process for how the death penalty chambers fixed. And that's the last point I will make, and I'll take up my time. Thank you, Mr. Chair. Is that we're still waiting for years to get this process to put some of the death down, yet our neighboring state up in Washington did it in a few months and was able to wrap that up. And there's these courts that keep stopping this.
All right.
May I respond to
that? Of course, and then we'll go to others.
Thank you. I do want to point out that there's been many efforts to move death row from San Quentin, and other counties don't want death row in their county. So I think that's important to know. I also want to point out that death penalty trials cost 20 times more than a life without possibility of parole trial. In addition to that, in other states where it's quicker means it takes about 10 years. I don't consider that swift justice. In addition to that, in those states, they have found many innocent people on death row and in their prison system. And DNA is only available in 20% of homicide cases. I have to say this, when I started at San Quentin, people tell me that every inmate will tell you they're innocent. That just didn't happen. And we believed that when people were there, they were guilty of the crimes. And through DNA, we have learned that our justice system is far from perfect. And what is there out there that we still don't know about? And to be the person to wake up every day, 30 to 60 days prior to an execution, to go to work, to plan to kill someone, the thought that that person might be innocent is more than you should ask of any public servant.
Right, thank you. Any other comments or questions? Mr. Knight?
Well, it's been a fairly long and educational bill that we've heard. What I have written down here is many things from the proponents of this bill. We want swift justice. We should be able to get a speedy justice. I think I'm going to just talk about a couple of things that Assemblyman Hagman spoke about. 10 years, I do believe, is a process that we can get to of where we can get that kind of speedy justice. If that is something that other states have achieved, obviously what we have done here in California is slowed down the process. We've done nothing to speed up the process. We have just slowed it down to now that we're at 25 years. Actually, we're at indefinite right now since no one has been executed since 2006. And with this bill, this is just a stay of execution for the 7 people who have gone through all of the appeals. These 7 people could be executed, but they have, this will be a stay of execution for these 7 by this bill. We will do that through the legislature. I have a problem with saying that taking away this punishment will not do anything because LWOP does the same. It is the same type of punishment. We're taking them off the street. They will never see the light of day again. The death penalty is a deterrent. It is. And it does have that effect on some people. I worked gangs for LAPD for 3.5 years. The death penalty is something that is in gang members' heads. It is not something that they talk about life without possibility of parole. That is just not an issue. I do believe that this starts us down the road of amending life without possibility of parole. I think that once we get this foot in the door, and I personally don't believe the voters would vote for this. The recent poll in 2010 said still 70% of people believe in the death penalty. They believe that this is a deterrent. And so that is not my opposition to this bill, because I think the voters would be sensible about this. But I do believe that this is starting the process of bringing groups forward, saying that there's got to be some point in life where we forgive somebody for this and they can leave prison. Now, I'm a forgiving person, but I'm also a person who believes in punishment, and I don't believe punishment is revenge. I think that when you have committed a crime in our society and there is that punishment, then that's the punishment you should receive upon conviction. The voters have said that. They have said this is the punishment that we deem is reasonable for these types of crimes, for these types of capital crimes, that we have taken a loved one away from our family, that there are these special circumstances. And so I think that the people will say again that the death penalty is a fitting punishment. But outside of that, I think that this bill is not crafted quite well because of the moratorium first. I don't think legislatively we should do that. We're taking a lot away from the governor right off the bat. And secondly, we are going down a road that is a penalty that is held for certain crimes that society has deemed these are the worst of the worst. There is that issue that I will never get over with the death penalty, that this is that crime, this is that punishment that fits that crime.
Thank you, sir. Do you want to respond briefly? There are other members who wish to speak as well. Do you want to?
I can try to respond briefly.
Sure.
Thank you, Assemblyman.
We've been meeting now for almost an hour, so
and
we'd like some closure eventually.
I'm happy to take questions also from the Assembly, but just briefly on the delays. There are, because of the danger of making a mistake, and Illinois, the governor signed the legislation replacing the death penalty with life imprisonment without parole because it had been discovered that they had executed 12 people who were innocent of the crimes. But so we do have both in our state constitution, we have not in California executed anyone wrongfully that we know. We know that 3 people have been exonerated while on death row, however, and the danger of making a mistake is there. Appeals and due process are guaranteed both by the California Constitution but also by the federal Constitution. And it is interesting that 70% of the cases that go on appeal are remanded to California courts even now because of mistakes in the record, because of a variety of things that send it back to the trial courts. I believe that the shortage of attorneys qualified to take these cases and the fact that the California reimbursement rate is so low and that it will tie up attorneys for a decade or more is one of the reasons that people can wait on death row for 6 or 7 years just to be assigned an attorney. Okay. And this is all, we want people who've committed terrible crimes to be removed from the rest of us so they don't hurt anybody else. But the money that we spend could be spent in better ways. So that's just a comment on the delays. But I'd happy to answer or try to have answered any other questions that members have.
Assemblyman Skinner, then Assemblyman Hill. Mitchell.
Thank you, Chair. I thought that the testimony by the three witnesses in support was very, very powerful and brought up aspects of this issue that I had not really considered. Yes, I was aware that the death penalty is quite costly to the state, but I wasn't aware of the very small number. I knew that we had only had a small number of executions, but I had no idea what it was in comparison to how many inmates we have on death row and how many inmates have either died naturally or committed suicide. In other words, the total number of people who we have given the death penalty versus the number we have actually executed. And the so in hearing that and various aspects of the cost and other angles that the witnesses presented to us, it really did for me, so sort of from regardless of what a person's moral view is on the death penalty or whether it's an appropriate punishment, it must be incredibly painful to the families of victims to basically be, there is no closure. And so, of course, I think there is that expectation that if ultimately the state does the execution, then they receive the closure. But because we, and I think it is right, that we do as a state, we must be very careful in our ultimate taking of the act, that even if there is a sentence, yes, we really do have to follow the full due process, because we really do have the obligation to not take the full act until there's absolutely no reasonable doubt around the person's guilt. And in this way, we do have a higher standard because it is the taking of a life. And that, of course, adds that much more to the cost, as you all pointed out. And yet it also adds no closure to the families of the victims. And it was very compelling to me then that we're not bringing resolution when really that's what it seems to me much of our sentencing's purpose is. And so the life without parole brings that kind of resolution. And clearly, while very costly, depending on the age the inmate is incarcerated, it is very costly to the state. But it would certainly free resources up for the addressing of the number of murders that we have unsolved and the various other issues that you raised. So I personally felt that the testimony was very compelling.
Okay. Assemblywoman Hill.
Thank you, Mr. Chair, and thank you, Senator Hancock, for our discussions and the conversations we've had. And I, too, have been kind of amazed by the statistics and the numbers, whether it's the number of those on death row today or those who have died naturally or the number that have been put to death through the system. And it's completely different. It's a completely different situation than we saw in 1978 when the voters approved Proposition 7. And I think this gives an opportunity for them to revisit that question, and I think it's timely to do that, especially based on all of the information that has now come to light. But I did want to explain my position on the bill. The analysis states that SB 490 abolishes the death penalty in California. And I want to make it clear that I'm not in favor of abolishing the death penalty through the legislature. What I am in favor of is giving the California voters the opportunity to weigh in on this issue, since the last time they had that chance was in 1978. So over the 30 years that have gone by, and from a public policy perspective, I think it's appropriate for Californians to review the facts, the circumstances, and the issues around the death penalty and how it affects the state and the fiscal conditions, and certainly the sensitivity of the victims as well needs to be addressed. And I think then the voters can make, hopefully after review, an informed decision at the ballot. So I'll be voting for the measure today, and to give Californians the opportunity to let their voice be heard. So,
thank you, sir. Assemblymember Mitchell.
Thank you, Mr. Chair. Just briefly, wanted to acknowledge your courage, Senator, for bringing forward, I think, one of our society's clear third rail kind of issues, both on a political front, on a personal front, on a moral front. And so I wanted to acknowledge you for that. I think it's ironic that we as a legislative body are confronting this issue in a fiscal context, given the multiple layers and the complexity of such an issue, such a critical issue, an issue that really reflects kind of the fundamental fabric of our society, that if an eye for an eye is really an appropriate way for a civilized society to engage itself. I will be supporting the measure today, and again, just wanted to acknowledge your courage in giving us the opportunity as an elected body to have a discussion at this point in time in our state's history, and given what our state is facing fiscally, to have a conversation about this critical issue. Thank you.
Assemblymember Cedillo, would you honor us?
Since you asked, I also applaud your courage in bringing forth legislation that is controversial and popular, but something you believe is the right thing to do. I will be candid with you and say that I am troubled by the vote that I have to take. I will say to you that I think there are some parts of the bill that I had not considered. Question of retroactivity is a question of actions we took before based on some circumstances, and now we propose a new law that may change. And it is, I think, unfair and disruptive to families who were living under one set of rules, and now we've changed that. I think there is merit and consideration to that. I accept the premise that cost should not be a factor, that the cost of justice should not be something that we evaluate based on the resources that we have. It's a factor in the administration and the execution, but we can't put a factor on what the moral costs are, and so I remain troubled. There are so many other factors involved for me that are maybe more important than that. I'm impressed by the warden here. Actually surprised and shocked in many respects by her testimony. It is very significant to have you here this morning. I actually believe that the death penalty may be a deterrent for purposes of law enforcement. I think there's a whole different world that exists in that community, and I'm troubled by that. I was very clear when I was elected, when I came to this legislature 14 years ago. I've had 14 years sitting on this in this committee, both in the Assembly and the Senate. It is not as clear for me today how to go forward. But it's interesting, and nor do I receive any relief that the public will make that decision, because too often that's dependent on who raises the resources and what campaigns are waged. And that's unfortunate, because we have too many laws that are more a result of the campaigns than of the cause. And in fact, the challenges and the problems we have, 3 strikes, et cetera, why our system is, and there is a consensus that why our system is dysfunctional, is in the part because it was more about the campaigns than the cause. about the rhetoric and more about the rhetoric than the reason. And in part, that's why we have the dysfunction we have. I don't know, I don't want to put you on the spot, but I do believe that there are some very thought-out concerns that were raised, both on the question of the law enforcement community and what it means to make this statement. And I think there are also thoughtful concerns that were raised on the question of retroactivity and what it means when people are prosecuted and participating in a process under one set of rules, and now those rules change, and now those circumstances change. And I don't know if we can accommodate either in this proposal, and ultimately, as my colleague Mr. Hill said, that will be a decision of the people. I thank you.
Yeah, I was
Thank you, sir.
going to say in my close.
Yeah, I was going to ask you if you would like to respond and make your close.
Yeah, I don't know if I can actually respond to all the many, many and multi-layered concerns, which I understand. I'd like to say that I look forward, if the bill moves forward, it is going to the Appropriations Committee, to working with the opposition to look at some of the issues they've raised on the legal language and retroactivity, and also the security of understanding that life without the possibility of parole in a maximum security California state prison is an appropriate punishment for these terrible crimes, and that it would not be the beginning of an erosion of that. We're talking about adult people here. And I would look forward to working with all of you. One of the reasons I felt it's so important to bring this bill was that, yes, we need safety and security in our communities, on our streets, in our schools. We need to believe that there are serious consequences for serious crimes. I believe that life imprisonment without the possibility of parole is one of those very serious imprisonments. In fact, there are many things that need to be further discussed about this. I look forward to continuing that discussion with the members who are voting for the bill today, with members who are opposed, and with both the people that have lived with this dysfunctional, failed system that is taking money away from our putting police officers on the street and teachers in the classroom at a time when our communities are diminishing because they do not have those things. So to work with everyone to begin a serious conversation, looking at data, looking at facts, and thinking about how we feel. Because as Senator Cedillo pointed out, this is also a matter of the heart and the gut for many people, and I understand that. We all want to see safe communities. We all want to see justice done. We need to give the people of California information and let the people decide. This bill is the first step in beginning that conversation, and I would ask for your aye vote.
All right, thank you very much. I just want to make a comment or two. Obviously, no matter what side of the issue you are on, and there's actually more than one or two issues. It's not really a black and white thing, which is what drives everybody crazy. I get it. But I do applaud you. I was excited about this hearing because I think we've tap danced around this, and who has a position, who's running for office, that is for or against, is it quite the litmus test? And in the meantime, there is a lot of suffering happening, particularly with the families. Yeah, cost is something to consider. Is it the main motivation? No, because there could be a way that the cost, as Assemblywoman Skinner intimated, that that cost could go into serving criminal justice in a fairer, more balanced way. None of us are God. Some of us think we're demigods. But you have presented to us something I think that someone like me, I've been waiting to chew on this. And I do think that the legislature, through the will of the people, needs to be prepared. Because I do see a day when there will be no death penalty. It may not happen with an initiative that's going to happen soon. However, I do think it's inevitable. And the collaboration, particularly with law enforcement, I don't want to blow off law enforcement here at all. I think particularly Mr. Knight, who has a street cred in that sense, is very sincere and has some issues of merit. But I think that's what we got elected for. So I will be recommending an aye to the committee, and if we could have a motion and a second. And a second. Okay.
As amended.
All right, as amended. Roll call, please.
Amiano.
Aye.
Amiano, aye. Knight. Knight, no. Cedillo.
Aye.
Cedillo, aye. Hagman. Hagman, no. Hill. Hill, aye. Mitchell. Mitchell, aye. Skinner. Skinner.
All right, the bill is out. Thank you very much.
Thank you.
All right, we have one more item. Senator Padilla. This is just a reso, ain't it?
Yes.
Please, I have you.
On assault weapon.
He used to work for Feinstein. Padilla. Okay.
Thank you, Mr. Chair, and particularly for allowing for the special hearing to be able to present SJR 7. I also want to thank the committee staff for their hard work. This resolution would put the state of California on record in support of both H.R. 308 as well as S. 32, both known as the Large Capacity Ammunition Feeding Device Act, both pending before Congress. This nation, and California is no exception, is all too familiar with significant tragedies with mass injuries and fatalities caused by mass shootings. From the Cleveland Elementary Schoolyard in Stockton back in 1989 to the law offices of Pettit and Martin in San Francisco in 1993 to the Long Island Railroad in Garden City, New York in December of 1993. We're all too familiar with these types of incidents. In 1994, in response, Congress acted in passing the Violent Crime Control and Law Enforcement Act, more commonly known as the assault weapons ban. The assault weapons ban adopted at the time included a ban on large capacity magazines. That act stood in place for 10 years, and in 2004, and since then, Congress has failed to renew that act. And since that time, we've heard of incidents including Virginia Tech with 33 fatalities, the Fort Hood military base with 13 killed, and most recently in January of this year in Tucson, Arizona, when a shooter used a Glock pistol equipped with a 30-round large-capacity magazine to kill 6 people, including a 9-year-old little girl and a federal judge, and injuring, among others, U.S. Representative Gabrielle Giffords. The point of policy is clear. While the assault weapons ban at the federal level has not been renewed, we have an opportunity to support at least an important provision of the previously standing assault weapons ban, and that's a ban on the large capacity magazines. It's actually in law here in the state of California. Not just the Roberti Roos assault weapons ban, but legislation authored by former Senator Don Parada banning the sale, import, etc. of these large capacity magazines in the state of California. And the proof, the evidence is clear. Since that California ban of large capacity magazines, we have not had any such tragedies take place within our state. But clearly there's a vulnerability. As long as these large capacity magazines continue to be made available in other states, we still run the risk of them finding their way unlawfully into California. To best protect Californians and the nation for that matter, I do believe reinstating the ban on large capacity magazines is good policy for our country, and this resolution before you would put this California legislature on record in support of that position. I ask for your aye vote.
Thank you very much, Senator. Witnesses in support, 2 minutes, 2 witnesses.
Good morning, and it is still morning. My name is Nick Wilcox. I'm speaking on behalf of the 22 chapters of the Brady Campaign to Prevent Gun Violence, and I'm also speaking today on behalf of the Legal Community Against Violence in San Francisco. I would just like to reinforce Senator Padilla's point that we need a national solution to this problem. We attended a gun show some years ago and asked a vendor how we could get a hold of a large capacity ammo clip, which of course were banned in California. He told us that he could not sell them to us, but he invited us to go to Nevada to get some for ourselves because we could simply then bring them back into the state, making ourselves criminals. The borders are leaky. We need a national solution. This resolution supports that. Some people will defend large capacity ammunition clips in regard to self-defense. I would submit to you that large capacity ammunition clips are really offensive weapons, that if you need to defend yourself, a 10-round clip is certainly adequate. I come from a hunting background, and I know of no hunters that use large capacity ammunition clips in pursuit of their sport.
Thank you.
So my name is Amanda Wilcox, and I'm here on behalf of the Nevada County chapter of the California chapters of the Brady Campaign to Prevent Gun Violence. It is difficult to switch gears here from the prior bill. But this is true violence prevention. That's why we're working on gun violence prevention to stop the killings in the first place. And certainly having a federal ban on large capacity magazines would stop the killing both in our nation and in California, as we do know that those large clips do come across the border. We actually have had a shooting in California since our ban went into effect. Nevada County, there's a shooting in Nevada County, a rampage shooting a little over 10 years ago. The gunman used a 30-round clip. Our daughter was killed in that shooting, as were 2 other people, and many were injured. Clearly, a large capacity magazine provides the opportunity for killing more people more quickly. It wouldn't have saved Laura's life, a ban. Laura was the first one killed. She was shot 4 times at point-blank range, her daughter Laura, but certainly other lives could have been saved. We don't know if the gunman had the clip already in his possession before California instituted its ban, or if it came across our borders, as Nick said. But clearly, those who think they needed a gun in the home for self-defense, a 10-round clip should accomplish that. Our borders are porous indeed, and we need a federal solution to this problem. I urge your support. Thank you.
Thank you so much. Any other witnesses in support?
Mark Carlson, Lutheran Office of Public Policy and Support. Just a historical footnote. In January 1989, the Cleveland school shooting took place. Patrick Purdy utilized high-capacity magazines. That church was adjacent to what was then Faith Lutheran Church. One of our members, a 6-year-old boy, nearly had his leg blown off, dealt with multiple surgeries. As you know, I think 29 students were wounded, a teacher, and 5 students were killed in that incident. Thank you.
Thank you, sir.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. We support having this legislature on record in support of the federal ban. Thank you.
All right, thank you. Are there any other witnesses in support? All right, seeing none, witnesses in opposition.
Good morning.
Good morning, Mr. Chair, members of the committee. Tom Pedersen, representing the California Rifle and Pistol Association. I'd just like to point out that our magazines, our high-capacity magazines in California, they're regulated, and they are regulated by California law, but they're not banned. And to take up the Senator's point, we haven't had any serious shootings in a number of years in California, and the fact of the matter is we still have high-capacity magazines here, but they're regulated. So magazines that were in place prior to the ban were allowed to be retained by the owners. And there is actually a legitimate use for such magazines. In service rifle matches, which are the service rifles used by the military, there are civilian competition matches, and in those matches, they're commonly used for those purposes. Just like to point out that although this federal ban did sunset, since that time there really hasn't been a lot of interest in reinstituting the ban because there hasn't been a lot of problems associated with it. There are those occasional tragedies that do occur, but those are criminals, and they should be dealt with as criminals. The equipment used will be there regardless. So for those reasons, we oppose it, but thank you for your time.
Thank you, sir. Next speaker, please.
Mr. Chairman, members of the committee, Ed Warder with the National Rifle Association. I respectfully disagree with the Senator. I discussed the issue with his staff, and we had a very nice discussion, philosophical debate, as always. Part of the issue here is that we talk about a ban. In the state of California right now, there are millions, and I say millions, of high-capacity magazines in public circulation, which are totally, completely legal. If you possess a magazine before the effective date of the law, no matter what its capacity was, you can lawfully retain it right now. So to say that you're going to institute a federal ban, or you're going to even institute what we have currently in California, the anomaly in the bill is very simple, is very interesting in California. It's also the same anomaly in the federal law, is that if you're a law enforcement officer and you want to buy a high-capacity magazine, not for use in duty, not to use in your weapon that's given to you by the agency, but for your own personal firearm, you can buy a high-capacity feeding device. So the question is for equal protection issues, if LAPD wants to give their officers high-capacity feeding devices for their weapons that they give the officers, that's one issue. But to have an unequal application of the law between a citizen and a law enforcement officer who's buying firearms for their own personal use that are not related to their duty is a violation of equal protection. Because the problem you have is that an officer, when they're off duty or they're not in doing their duty, is a citizen like everyone else. When you ask officers why they want a high-capacity ammunition magazine for their off-duty weapon, they say, I need it for self-defense. And I submit to you that if an officer needs one for self-defense, so do I. So if you're going to make a ban, let's make it a ban. Don't let officers buy them off-duty either.
All right, sir.
Thank you very much.
Thank you. Before we, let me just say, are there any other witnesses in opposition? All right, seeing none. Assemblyman Skidder?
Thank you,
agenda.
Mr. Chair, and thank you, Senator Padilla, for introducing the bill. I support the California legislature being on record on this. I think that there was discussion that it was violence prevention. I don't believe that it's violence prevention, but I do believe it would limit the number of deaths, which I think is very essential. But I will say that I thought the representative of the National Rifle Association made a very good point. And I would support an amendment that I think that it should not, if our purpose is trying to limit these large magazines, and because of their use in rampages almost ensures a higher number of deaths because of the speed at which the bullets are issued. And even if in the case with Tucson, where there were law enforcement present and security, you can't intercede fast enough, even if you're right next to the individual. So to me, that's why such magazines should be banned entirely and shouldn't even be used by law enforcement in terms for personal use. So I don't know if the committee had looked at such an amendment, but it's certainly an amendment I would support. I'm not saying we have to take it today, but it certainly is one I would support. But I do thank you for introducing the bill, and I would move the bill.
Just a slight correction. It's a resolution.
Yeah, if I may,
Rather,
just
I would
wanted
move
to
the
clarify. This is
resolution.
a resolution in support of the federal legislation But I think, per your comments, Member Skinner, legislation would be in order for consideration to amend California's ban as it appears in statute.
All right, thank you. Any other comments?
Just a quick comment. This was brought forward by Democratic Congress back in the middle 90s. It was not renewed, and now we have the House is majority by Republicans. Why was it not renewed when the Democrats had the House or had the Congress?
I think at the time we also had a Republican president, for starters. And in the early 90s, we did have a Republican Congress.
And there was a period where you had a Democratic president there, too.
Right.
And it was not renewed.
That Republican president.
And I don't want to make this a distinction between a Republican and a Democrat, but I'm saying that it was brought forward by the Democratic Congress. They had a chance to renew it. They didn't. So I just think that there's...
To really have that discussion, we have to also consider what the rules of the game are in the United States Senate, not just the Congress in totality, in the Senate where you need 60 votes for things to move forward. So even though it's a majority Democratic Congress, or U.S. Senate for that matter, you still require Republicans to allow for such a vote.
All right. Thank you. Okay. Do you want to close?
The bill? I think the issue is pretty clear, and I would respectfully ask for your vote.
All right. I need a motion and a second.
the bill.
You moved it already? A second? Who seconded? All right, Mr. Seal, thank you very much. And Senator, thank you for bringing this to us. I know that Senator Feinstein was mayor, unfortunately, by circumstances, not unfortunately that she was mayor, and that she has, for years, had this issue on her front burner. So my recommendation is an aye. I think it's a justifiable resolution. So we have a roll call, please.
Amiano?
Aye.
Amiano, aye. Knight?
No.
Knight, no. Cedillo? Aye. Cedillo, aye. Hagman? Hagman, no. Hill? Hill, aye. Mitchell? Aye. Mitchell, aye. Skinner? Aye. Skinner, aye. It's out.
All right, the bill is out. Thank you very much. And seeing no other business, we will adjourn the meeting. Thank you.